Good afternoon. Thank you for registering for today's webinar. Today's webinar will focus on two employment topics important to banks. First, I will discuss how you can create an enforceable non-compete agreement. Specifically, I am going to give you the top 10 ways to create an enforceable non-compete agreement. Second, I will review new diversity standards impacting banks and what steps your bank should take to comply with these standards. If at any time you have a question, please do not hesitate to ask. You can type in your question in the chat box located on your screen. Also, if you'd like a copy of my PowerPoint, you can always send me an email. My email address is on the first slide that you should see in front of you today. To get started, we're going to talk about creating enforceable non-compete agreements. Banks, like many employers, rely on employees to develop proprietary processes and special relationships in order to develop their business. Those employees can come into contact with trade secrets and proprietary information that is extremely valuable to the bank and not otherwise publicly available. They can also come into contact with customers in such a way as to develop a personal hold on the goodwill of the bank. So how does a bank protect its goodwill and confidential information in the event an employee leaves? The natural answer is a non-compete agreement. If the employee leaves the bank, he or she cannot work at a competing bank for a designated period of time. The non-compete period enables the bank to train new employees or transfer customer loyalty to other employees from competition from the separated employee. In addition, in the chance that there's a breach of the non-compete, an enforceable non-compete agreement allows the bank to stop or enjoin the former employee from engaging in the prohibited conduct during the pendency of the lawsuit. It also allows the employer to seek damages such as lost profits. So this sounds simple, right? Well, what I'm about to tell you is the answer to that question is not always. During employment, it is typical to prohibit an employee from competing against the bank. However, holding the employee to the same standard after he or she leaves the bank is another story. And that's why it is critical that you create an enforceable non-compete agreements with some of your employees. So the first item that you need to consider when putting together a non-compete agreement is the timing and the consideration you're going to give to the employee in exchange for signing the non-compete. Ideally, you would want to give the employee the non-compete agreement at the beginning of their employment or with the initial offer of employment. Typically, it can be included in as a term of an employment agreement. With respect to consideration, in Iowa, the actual offer of employment is considered consideration. In addition, continued employment is considered sufficient consideration. However, if you have an independent contract, continued employment or a continued relationship would not be considered sufficient consideration. Therefore, if you didn't offer a non-compete to an independent contractor at the beginning of the relationship, you would need to provide them with some additional consideration, such as a raise or a new bonus, in order to get them to sign a non-compete agreement. The second item you need to consider is that the non-compete agreement must protect a legitimate bank interest. In Iowa, legitimate bank interests include goodwill, including the goodwill of customers, special training, peculiar knowledge, trade secrets, and/or confidential information. With respect to this, employers such as banks must establish that they are not seeking the non-compete agreement as a matter of routine. So for example, you can't ask for a non-compete from every single employee in your organization, regardless of whether it is needed to protect a legitimate business interest. A perfect example of this would be offering a non-compete agreement to a receptionist who may or may not have any contact with or connection to trade secrets or confidential information. In the same respect, you need to make sure that it is seeking to protect something that bears some relationship to the employee's activities. So ask yourself, does the employee have access to trade secrets and or confidential information? Does the employee have direct access and a good relationship with customers? In addition, employers cannot impose non-compete requirements on employees for purely punitive or anti-competitive reasons. The next item you need to consider is whether the non-compete is reasonably necessary to protect the bank's legitimate business interests. In Iowa, courts apply a three-part balancing test to determine whether a non-compete agreement is enforceable. Now this three-part balancing test is laid out there on the slide. It's the first prong is the terms cannot be wider than what is reasonably necessary to protect the former employer's business. It cannot impose an undue hardship on the former employee, and it cannot be prejudicial to the public interest. In this webinar, I'm going to focus for the most part on the first prong, touch briefly on the second prong. I'm not going to go into too much detail into the third prong because it does not come up as often as the first and the second prong do. One thing to keep in mind with respect to establishing reasonableness is that it is always the burden of the employer to establish reasonableness. The employee will not have that burden. So just with respect to the fourth item, I'm going to get deeper into the reasonableness. So how do you determine whether your non-compete is reasonably necessary to protect the legitimate interests of the bank? Well, the courts are going to look at a number of factors, including where the bank's clients are located, the nature of the employee's job duties, how reliant the bank is upon the particular employee to develop and or preserve business relationships with customers, the nature of the trade secret or confidential information, how long it would take to transfer customer loyalty to different employees, and how long it would take to train the employee's relationship. Because these and other factors will vary from bank to bank and industry to industry, there is no blanket accepted time or geographic limit on non-competes. But with that said, when deciding on the scope and the duration of non-compete, which I'll discuss in more detail later on, most jobs would not justify a nationwide non-compete or a non-compete in excess of a year or two, at least not in Iowa. Moving to the fifth item that you need to consider, and this is related to the geographic restriction. So what area do you want to restrict your employee from competing? In Iowa, courts generally find geographic restrictions of 20 to 40 miles to be enforceable. Unlimited geographic restrictions are unenforceable, as well as nationwide restrictions, which I mentioned before. Again, the validity of a geographic restriction depends on the nature of the bank's business, the geography in which the employee actually worked, the location of customers, and whether the restrictions would cause an undue hardship on the employee. Now, just as an example of this, let's say you have a loan officer who works for a bank in southeast Iowa and has customers and relationships with these customers in Lee County, Des Moines County, and Louisa County. In that case, the court would likely uphold a 3-county geographic restriction, even though it covers more than the 40 miles that I mentioned previously, and that's because that is where the employee's customers are located. Again, a statewide geographic restriction would be okay if your customers were located throughout the state of Iowa. The sixth item you want to consider is whether you want to use a customer-specific restriction in lieu of a geographic restriction. That's because in Iowa, courts will uphold customer-specific restrictions. And this is a type of restriction that restricts the employee from working with specific companies or clients with whom the employee directly does business with during their employment. You can do this in one of two ways. You can attach a specific list of customers to the non-compete agreement, or you can be more vague and simply say any and all customers that the employee came in contact with during their employment and did business with, or something like that. The seventh consideration you need to make is how long you want the employee to be restricted from competing against the bank. In Iowa, courts will generally uphold a 2-year restriction. Greater restrictions have been upheld. However, it's challenging to show that these are reasonably necessary to protect the employer's legitimate interests. And then, as I said before, an unlimited duration is unenforceable. Like I said earlier, courts will look at the reasonableness factors to determine whether the temporal restriction is reasonable. Courts will also look at the geographic restriction and the temporal restriction together and focus on whether there's a balance. So, for example, if the geographic restriction is extremely narrow, let's say 10 miles, but the duration is 3 years, the court may uphold that restriction because there's a good balance between the geographic restriction and the temporal restriction. By the same token, if the geographic restriction is broad, let's say it's statewide, but the duration is short, say for 6 months, that may be okay because there's a good balance between those two restrictions. Moving on to the eighth consideration a bank needs to make when creating a non-compete agreement, and that is whether it has executed non-competes with any other employees. So in Iowa, courts will look at whether the bank has executed less restrictive non-competes with other employees, and this is especially true if you have employees who work in the exact same position as the employee that you're trying to seek enforcement of the non-compete against now. So let's say, for example, if you have a loan officer, Bob Smith, and he has a 2-year post-termination non-compete, but a loan officer, Jane Smith, only has a 6-month non-compete, it would be difficult for you to justify how Bob's non-compete is reasonable to protect legitimate business interests when you are okay with Jane only having a 6-month non-compete. So it's important that you stay consistent with your employees. Of course, if one employee works in a different type of position or has significantly different job duties, you may be able to justify a difference there. The ninth item you need to focus on, and this goes back to the second prong of Iowa's balancing test, is whether the non-compete agreement imposes an undue hardship on the former employee. To determine whether there's an undue hardship, the courts are going to look at those factors that we just examined, the temporal and geographic limitations, as well as the nature of the employee's occupation. But they're also going to look at the basic fairness of the non-compete. For instance, can the employee make a living and support his or her family with the non-compete in place? In addition, did the employee actually have enough customers to justify a non-compete? One important item to remember when drafting a non-compete is that let's say you draft a non-compete that is technically unenforceable because for whatever reason your temporal restriction is too strict or even your geographic limitation is too strict. In Iowa, courts will modify or partially enforce a non-compete agreement that is unenforceable as originally drafted, and this is a good thing. So if you end up in court with a non-compete agreement that has a nationwide geographic restriction and a time limitation of 3 years, the court will say, well, that's unreasonable, but we will modify this so that it's a 2-year restriction and only applies to this particular county. Now, this doesn't mean you should just kind of draft a non-compete in whatever way you want to. You want to make sure it's enforceable going into court rather than having the court dictate what it finds to be the best situation for your case. That's the next number 10, and this isn't really how to create an enforceable non-compete, but I wanted to make you aware that if you do have a non-compete agreement with an employee, you might as well have the whole package, and that would include a non-solicitation provision as well as a confidentiality provision. With respect to the non-solicitation provision, the court is going to apply the same test for enforceability as it would to non-competes, with one exception, and that is to the geographic considerations. For a non-solicitation provision, you have to limit it to the clients or customers with whom the employee had contact. You can't just make it to cover any and all customers of the bank. It's also important to know that you can prohibit both direct and indirect solicitation of employees and customers. And non-solicitation provisions are particularly enforceable where the employee was the face of the bank. With respect to confidentiality provision, this would be contained in a non-disclosure clause, and again, it has the same test of enforceability as non-competes do in Iowa, except for the temporal and geographic considerations. Importantly, non-disclosure clauses can be for an indefinite time and do not need to have a geographic restriction. This means if you have a loan officer who's working for you in northwest Iowa and he's privy to trade secrets and confidential information, this loan officer can't go to California and use your trade secrets and confidential information in order to compete against the bank or to do anything in his future employment. So this is particularly important. It's also important to note that if you do not have a non-disclosure clause in an agreement, you would still be protected by the common law in Iowa, which prohibits employees from disclosing proprietary information. You'd also be protected from the Iowa Uniform Trade Secrets Act, which prohibits employees from disclosing trade secrets. That's all I have on creating an enforceable non-compete agreement. I did want to touch briefly on the impact of hiring an employee with a non-compete agreement already in place. So let's say he or she is coming from another bank in Iowa or even out of state. You need to make sure you ask all of your employees, especially the higher level ones who are going to have contact with your trade secrets, whether they have a non-compete in place prior to them joining your bank. You also need to see the agreement and see exactly what it says, even have legal counsel review it so you know you're protected and not going to be violating that. Because if the employee violates their own non-compete agreement with another entity, your bank could also be liable for that breach. I would also advise you to take everything one step further and have the employee agree in writing that he's not in breach of his current non-compete agreement, and have him agree to indemnify the bank should the other entity file suit against the bank. That's all I have on non-competes agreements. I was going to move on to our next topic of diversity standards. Does anyone have any questions over non-competes at this time? Seeing no questions, I'll go ahead and move on to the diversity standards. But if at any time you have a question, you can put it in the chat box, or else you can email me after the webinar, and I'd be happy to help you out. So, as you may know, in 2010, Congress enacted the DoddFrank Act to remedy the perceived failures of government regulators and to improve accountability and transparency in the U.S. financial system. Among the mandates included in Dodd-Frank is a provision intended to address the diversity policies and practices of financial entities such as banks. Just by way of background, the lack of employment diversity in the financial services sector has been well documented. According to an April 2013 report of the U.S. Government Accountability Office, women represent approximately 30 to 36% of senior management positions in financial services sector. With respect to minorities, the percentage is even lower. They represent approximately 11 to 17% of senior management positions in the financial services sector. So to address the lack of diversity in the financial services sector, proposed diversity standards were issued more than a year ago pursuant to Dodd-Frank. These standards are not yet in effect. However, it is likely they will be adopted in the near future. They were supposed to be adopted by the end of 2014, but that has been pushed back. So I estimate that at the latest they would be adopted by the end of 2015. Just to give you some background, Section 342 of the Dodd-Frank Act is what we're discussing here. And this particular section established the Offices of Minority and Women Inclusion. I'm going to refer to that as OMWI, at several financial agencies, including the SEC, the Consumer Financial Protection Bureau, and the FDIC. Also, you're going to see exactly what has been mandated for each director of these agencies. For the office. I'm not going to read that to you because you can read it on the slide. But just to kind of put it in plain English, what does this actually mean? Well, the directors have been charged with three main items, and the first is to develop diversity standards for their own agency's workforce. The second is to increase participation of minority and female-owned businesses in the agency's programs and contracts. And third, and this is the thing we're going to concentrate on today, is assessing the diversity standards and practices of financial entities such as banks, which are regulated by the agencies that are covered by the Act. So the proposed standards focus on transparency and awareness of diversity practices within the agencies and the entities they regulate, such as banks, which I'm going to discuss here, the 4 areas that they are highlighting. Just to point out, they don't prescribe any quotas or mandate specific actions or impose specific penalties, which is good news to banks. More importantly, the agencies will not use the examination or supervision process in connection with these proposed standards. And lastly, the proposed standards take into consideration an entity's size and other characteristics, for example, total assets, number of employees, geographic location, and community characteristics, which is good for banks in Iowa, especially small-town banks, which might not have a very high minority population or even a high female population. So the 4 areas that the joint proposed standards highlight are listed on your screen in front of you. The first, and I'm going to take these each individually, the first is organizational commitment to diversity and inclusion. Second is workforce profile and employment practices. Third is procurement and business practices, specifically concentrating on supplier diversity. And the fourth is practices to promote transparency of organizational diversity and inclusion. So for the first one, organizational commitment to diversity and inclusion. The proposed standards say that financial entities such as banks should have a diversity and inclusion policy approved and supported by senior management and its board. They should also have senior level officials dedicated to resources to oversee and direct the diversity efforts, and they need to make sure they're taking proactive steps to promote a diverse pool of candidates for senior leadership and board positions. The next item is workforce profile and employment practices. Now, with respect to this, the joint proposed standards state that the entity should have policies and practices that create diverse applicant pools for both internal and external opportunities. For instance, they would like to see outreach to minority and female organizations. They'd like to see outreach to educational institutions that attract minorities and females. And they also would like to see banks participate in conferences and workshops and other events that attract minorities and women. With respect to this area, they also want the bank to hold management accountable for diversity and inclusion efforts, and they want to make sure that the bank is using some sort of tool to measure their workforce diversity and inclusion efforts, such as applicant tracking, recruitment, and hiring. For those of you who already have to file an annual EEO-1 report, as is required by Title VII of the Civil Rights Act, or even entities that prepare annual affirmative action plans, this would be a good way to track your workforce diversity and inclusion efforts, and would take care of this particular prong of this area. If you're not sure if you are covered and required to file either an EEO-1 report or an affirmative action plan, you can send me an email after the webinar, and I can let you know whether you are required to do that. Then the third area that the joint proposed standards focus on is procurement and business practices specific to supplier diversity. Now this is essentially what you're doing with respect to employees. You need to be doing the same with respect to suppliers. So you need to have a supplier diversity policy that provides a fair opportunity for minority-owned and women-owned businesses to compete in procurement of business goods and services. Now this includes all types of contracts, including contracts for the issuance of guarantee of any sort of debt. Again, the entity also has to have some sort of method to evaluate and assess its supplier diversity, and it needs to promote a diverse supplier pool by doing outreach, reaching out to educational institutions, or participating in conferences, workshops, and other events that would attract minority-owned and women-owned businesses. Lastly, and I don't have this listed here on the slide, but the proposed standards also say that the bank or the financial entity should publish opportunities to procure goods and services for that bank. The next item, or the last item that the proposed standards focus on, is practices to promote transparency of organizational diversity and inclusion. And this encourages entities to annually publish via the website or newspaper the following: its diversity and inclusion strategic plan, its commitment to diversity and inclusion, and its progress towards achieving diversity and inclusion in the workforce and procurement activities. It also encourages financial entities to publish their demographic profiles of their workforce and suppliers. So with all of these areas that the joint standards focus on, they also propose an approach to how a bank such as yourself can assess whether it's complying with diversity standards. So the first item they suggest is to do a self-assessment utilizing the proposed standards to conduct a quantitative and qualitative evaluation of the diversity and inclusion policies and practices, which I laid out previously. They also encourage voluntary disclosure to the appropriate agency, whether that's the SEC or the FDIC, of the self-assessment and other information the entity deems relevant. The agencies have stated that they will monitor the information submitted over time for use as a resource in carrying out their diversity and inclusion responsibilities. They also encourage the entity to display the information on its public website and in its annual reports and in other materials regarding its efforts to comply with these proposed standards as an opportunity for more public awareness and understanding of its diversity policies and practices. The agencies have stated that they may periodically review information on regulated entities' public websites to monitor diversity and inclusion practices. So what do you really have to take away from this? Well, as I said before, the proposed standards are just proposed at this time. They are not in effect. But there's two things. I mean, it's good that you're aware, and then the second thing is you need to be proactive. So to be proactive, I would suggest that you review your current diversity policies and practices. Hopefully all of you have some sort of EEO policy already in place, but I'd encourage you to take a look at that policy and maybe expand on it to cover these sorts of the standards articulated here, as well as to define the type of diversity the bank intends to encourage. And this is pretty important because the standards do not define diversity, so they're leaving that up to the banks for now. And to also be proactive, you should create or even start the discussion about what diversity objectives your bank would like to promote relative to its own business goals. I think at this point, since the standards are only in proposed form, if you don't want to do anything concrete, you can at least get the discussion started. Again, there's no quotas, there's no specific actions, and there's no penalties in the proposed standards. So they're putting this on the banks and other financial entities to improve diversity policies and practices. That's all I have for you today. I hope you've enjoyed the webinar. If you have any questions concerning non-compete agreements or the proposed standards under the DoddFrank Act, I'd be happy to answer them. My contact information is located on this last slide. I'd also be happy to send you my PowerPoint. Just shoot me an email, and I'd be happy to send it to you. Any questions for now? Seeing no questions, I will go ahead and sign off, but again, you can always give me a call or contact me via email if you have any questions regarding the topics we've covered here or have any other employment-related issues. Thank you again for attending, and I hope you all have a great day. Thanks. Bye.